Okay, I guess, excuse me, I guess it's time to start. And I'd like to thank everyone for attending the Committee of Adjustment meeting. And I'd like to remind everyone as we get underway that the meeting is in person and online through Zoom and is being recorded. Everyone online will be muted with the exception of committee members and staff. All comments and questions are to be directed through the chair from committee members, staff, and the public. I'd like to remind committee members that you must speak into your microphone so everyone online and in person can hear you. For those attendees that are online, your video picture will not be displayed and you will be muted and will not be able to unmute yourself during an application that you have not requested to attend unless you raise your hand. At the beginning of each application, I will call the applicant forward. The owner or applicant in attendance may come to the table to their right to speak with the committee. This microphone is live and you must speak into it. If the owner or applicant is online, you will be unmuted. The committee will ask for comments from the public during each application. Please provide your name and address for the public record. All comments, questions should be directed to the chair and only speak when it's your turn. If you're in person and would like to speak to an application one at a time, you may approach the podium and speak. This microphone is also live. If you're on the video portion of the Zoom meeting and you'd like to speak and your microphone is muted, please click on the raise hand button located in the bottom of your screen. Staff will notify me that you wish to speak. If you're attending by telephone and you wish to speak, please dial *9 to raise your hand, which will signal staff that you wish to speak. Once a decision has been made concerning your application, you're welcome to leave the hearing while the committee continues with the next application. Members in attendance today are Catherine Graham, Bruce Craig, Paul Veenstra, Todd Robertson, and myself, Jim Keel. Our staff in attendance are Senior Planner Lindsay Lambert, Planner Kyle Peel, Secretary Treasurer Amanda Werner-McKellar, and Planning Student Nick Carter. The first item on the agenda is the adoption of the agenda. Any committee members have any changes they wish to make?
I have none.
None here.
No. No, sir.
Nor do I. So I need a mover and a seconder to accept the agenda. Moved by Catherine, seconded by Paul. That the agenda be adopted as circulated. Ready to vote?
Catherine, yes.
Bruce, yes.
Yes. Yes.
I am also carried. Second item on the agenda is the adoption of the minutes from our June 24th, 25 meeting. Do any committee members have any changes or suggestions they wish to make? Catherine?
I have none.
None here.
Nope. None.
Nor do I. So we need a mover and a seconder again. Moved by Bruce, seconded by Todd. That the minutes of the June 24th, 2025 hearing of the Committee of Adjustment be adopted as circulated. All in favor?
Yes.
Yes.
Yes. Yes.
And I am also carried. So declaration of interest. Any members have a pecuniary or any other declaration they wish to make? Kevin?
None.
None here.
No. None, sir.
Nope, nor do I. Okay, the first application today is D13-2025-024 69 Benson Park Road. Amanda, would you like to give us your story on this?
Yes, and we have the owner online if you have any questions. The subject application is requesting a permission for the proposed expansion to the existing legal non-complying dwelling. The existing dwelling is a legal non-complying structure that does not comply with the minimum 30-meter setback from the high water mark of the St. Lawrence River and does not comply with the minimum 30-meter front yard setback of the island residential zone. Of note, the applicant received approval from the Committee of Adjustment on September 24th, 2024 to rebuild the existing legal non-complying dwelling from the existing foundation and expand it with an addition on the west side of the attached covered decking. The subject application is seeking an additional expansion at the southeast corner of the dwelling, which will increase the floor area of the legal non-complying dwelling. The additional floor area included in this application is 22.3 square meters.
Okay, thank you, Amanda. Lindsay, would you give us your report, please?
Thank you, Chair, and through you. So as noted, this is a permission application for an addition to the southeast side of the existing dwelling. There was a previous permission application approved last year through this committee for the reconstruction of the dwelling and an addition on the west side. This permission is seeking to further expand the dwelling through that 23.3 square meter addition on the southeast side. In staff's review of the application, it's noted that the addition is on the non-water side of the property of the dwelling. It is consistent with the policy test established through the township's official plan for the expansion of a legal non-complying structure. No concerns have been received to date from members of the public or the township departments or external agencies that were circulated on the application. The CRCA, being one of those agencies, has noted no concerns from a natural hazards policy and regulatory perspective. They do note that the scope of work will require a permit under Regulation 4124. And therefore, staff overall recommend approval of the application in accordance with the details and conditions enclosed within the staff report. Thank you.
Yeah, thank you. Amanda, any other public comments received?
We just received the comments from the Conservation Authority with no objections, and we have not received any further written public comments.
Okay, thank you. Is there anyone here in attendance that wishes to speak to this application here in the public here?
We have no one in the audience. Oh, Donnie? Yep, go ahead. This is the owner.
Oh, no, I didn't. Sorry, I don't know. I'm good.
Okay. Yeah,
Sorry about that.
No problem. We have no one else in the audience looking to speak to the application, whether that's online or in the building here.
Okay, committee members, we'll start with Catherine. Any questions for the applicant?
Just so I'm absolutely clear, this addition is a one-story addition with a deck on the roof. Is that correct?
No, it's an addition to it's just addition of our bedroom and ensuite and no deck on the roof at all.
Oh, okay. So
Yeah.
it's a one-story addition.
Yes.
The area was clearly marked, so thank you for that, but I just wanted to make sure. Thank you very much. I have no questions or concerns.
Okay, Bruce.
I have no concerns. The additional floor space is away from the river, so I'm good with it.
Yeah, Paul?
Yeah, nothing here.
Yeah.
Nothing here as well.
No, nor do I. So, we need to move in a second. Mover in a second. Moved by Catherine, seconded by Bruce. That application D13-2025-024 be approved, subject to the conditions as included in the planner's report and the decision of the committee, and we're ready to vote. Catherine?
Yes.
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 I am also carried. Okay, second on our agenda today is D13-2025-025-971 Newells Lane. And Amanda, will you give us your story on this?
Yes, we have the agent online, and if there's anybody in the audience that wants to speak, they're welcome to come to the table as well. Oh, I'm sorry, I'm on the wrong one. Okay. Yeah. Sorry, this is for 971 Newells Lane. The application is requesting a permission to replace an existing legal non-complying dwelling and expand the floor area and height. The existing dwelling is a legal non-complying with respect to the minimum 30-meter setback from the high water mark of Bass Lake and the minimum 30-meter front yard provision of the shoreline residential zone for the township zoning bylaw. The existing structure features 115.9 square meters of floor area and is proposed to be demolished and replaced with a 1.5-story dwelling with a 133.5 square meters of floor area, including an attached garage. The height of the structure is proposed to increase from 8 meters to 8.92 meters. The subject property is currently developed with an existing dwelling, an attached open deck, and 2 accessory structures. The application is also seeking variance with respect to the minimum rear yard setback of the proposed dwelling and the maximum permitted shoreline occupancy of the existing marine facility. The existing dock was constructed in absence of municipal planning approval.
Okay, thank you, Amanda. Kyle, would you give us your?
Thank you, Chair, and through you. So as noted, this is a combined variance and permission application which involves the demolition of the existing house and replacement with a expanded structure in terms of ground floor area and height. Further, the application is seeking to legalize an existing marine facility. So in terms of the dwelling, the structure will maintain the existing setback. It's actually further setback by, I believe, 0.5 meters. The expansion of the structure will include approximately 18 square meters in additional ground floor area, but it is noted that the gross floor area of the structure will decrease through this application. As noted, the height is proposed to increase from 8 meters to 8.92 meters. Staff believe this increase to be modest, both in terms of ground floor area as well as height. Further, as noted, the setback will be maintained, which will allow for that area to be enhanced with native vegetation as per our recommendations included with the staff report. In terms of the marine facilities, the structure was expanded to add a small addition, sort of to create an L-shaped dock. This created an expansion beyond the maximum permitted width for a marine facility, which is 20% of the shoreline. The deck as it stands is at 24%. Again, this expansion is understood to be modest by the Township Planning Department, and we have no concerns with it. Further, due to the location of the property, it is surrounded by a large piece of vacant land. As such, the closest marine facility is over 70 meters away, which reduces any impact to neighboring properties. With that said, the Conservation Authority have also submitted comments noting no concerns with the subject application, and staff have reviewed the applicable policy documents and would note no concerns. As such, we recommend approval of this application per the details and conditions enclosed within the staff report. Thank you.
Thanks, Kyle. Amanda, were there any other public comments that you've received?
No, we just received the comments from the Conservation Authority with no objections, and we have not received any further written public comments.
Thanks, Amanda. Is there anyone in attendance today or online that wishes to speak to the application?
Anthony Willemaker of Greeley, Ontario, agent for the owner. Thank you, committee chair, committee members. I just wanted to note, and I hope this we can get this fixed today, or if it has to be fixed, that we didn't ask specifically for a variance on the, even though it's listed on the 30 meters water setback, which it's in there, but it's not listed as a variance. So is that something that we can put in as a condition or add in here at this meeting?
Yeah, so I can speak to that. So because this is a permission application, i.e. we have an existing legal non-complying structure, we wouldn't do a variance for the 30-meter setback. It would just be a permission because we're expanding that structure.
Okay.
If we were building a new structure within the 30-meter setback, we would vary it to include a variance that states, the reduction is 15 meters from the 30-meter setback.
Gotcha.
But because this is a permission application, that's not necessary.
Okay, well, that's good to know for next time then. Yeah, so Kyle and Amanda set it out. I don't know if you have any questions for the committee, has any questions for me or the applicant or the owner. We're both here.
So with you, Catherine, you're
No. Sorry, one second. We don't have any further comments from the public, from the audience, or online.
Go ahead, Catherine.
So I have no questions or concern. I compliment you on the staking of the property. It was
Oh.
very easy to see what was going on.
Good, yeah, that was the intent.
I also have no concerns with the variance on the dock.
Bruce?
Yeah, my only question was if the dock was included in this application. I think Kyle addressed that, so I'm good with it.
Yeah, Paul?
Yeah, no, nothing here.
Yeah, Todd?
A question for Kyle through you, Chair, and it's just an information question for me. The width, is that measured at the shoreline or is that at the widest point of the docking structure itself? Like if it was out in the water and it was wider in the water than it was the shore, just sort of for my information.
Yeah, so the it would be taken by the widest part of the dock overall. So yeah, if it extends out into the water and then goes left or right, similar to this application, that's how the width would be measured.
So it's not at the actual shoreline, it's the widest part of the structure.
Exactly.
Perfect. Thank you.
Okay, no, and I have no questions here, problem.
Okay, thank you.
Good. We'll need a mover and a seconder, moved by Catherine, seconded by Todd. Moved by Catherine, seconded by Todd, that application D13-2025-025 be approved, subject to the conditions as included in the planner's report and decision of the committee. And we're ready to vote.
Catherine, yes?
Bruce, yes. Yes.
Yes.
And I am also carried. You're welcome. Now, third on the agenda today is D13-2025-026-912 Kendricks Lane. Would you give us your information, Amanda?
Yes, and this time I have it right, and the agent has been called forward. So this is for 912 Kendrick. So the application is requesting a permission to replace an existing legal non-complying dwelling and expand the floor area and height. The existing dwelling is illegal non-complying with respect to the minimum 30-meter setback from the high watermark of Lower Beverly Lake and the minimum 30-meter front yard provision of the shoreline residential zone. The existing 95 square meter dwelling is proposed to be demolished and replaced with a 203 square meter single story dwelling. The height of the structure is proposed to increase from 3 meters to 6 meters. The property is currently developed with a single detached dwelling, 2 accessory structures, and 2 sleeping cabins. One of the sleeping cabins and the outdoor kitchen are proposed to be demolished.
Okay, thank you, Amanda. Kyle, would you give us your report, please?
Thank you, Chair, and through you. So as noted by Amanda, this application is a permission application which proposes to demolish the existing dwelling and build a larger structure in its place. So the existing setback will be maintained through this proposal. It will be an identical setback as existing. The existing structure is approximately 95 square meters, and the expansion will be 203 square meters. Despite this increase, the overall lot coverage will remain compliant with the provisions of the zone. The increase of the height is proposed to add an additional 3 meters for a total of 6 meters. The maximum permitted height for a dwelling is 12 meters, so this is still well under the maximum permitted height. Staff believe this proposed development is in proportion to surrounding properties, and the size and scale of the development is proportional. Based on staff's review, we have no concerns with the application. However, I will note that there was a public comment noting concerns with the application. So I'm just going to run through some of these concerns and follow up with staff's response. So the first complaint was that the structure essentially should not be rebuilt within the 30-meter setback. So I would just clarify that the existing dwelling does have legal non-complying rights. So what that means is the structure was lawfully constructed in compliance with the zoning provisions in effect at the time, but no longer confirms the current zoning requirements. These legal non-complying rights allow the structure to remain and be used in its current form. However, any proposed expansion of the structure is subject to minor variance approval, which has brought us here today. There was also a note about whether or not the septic was set up for the increasing quantity of people. So I can confirm that the applicant is in talks with our chief building official regarding the septic system. Further, there will be additional review through the building permit process, and the structure will be required to be assessed for competency prior to occupancy of the new dwelling.
Sorry, Kyle, can I say something?
Sure.
I'm Eamon O'Leary. I'm the agent for the owner here. I just want, does the letter say that we're adding more people?
It says that you would essentially have the capacity to add more people. That's correct.
Okay. Thank you.
Okay. There was also a note about the shed by the water. I would just note that similar to the dwelling, the shed appears to be a legal non-complying structure that would have rights to the existing footprint. As such, it's not required that the shed be moved. There was a note about whether this would set any legal precedent in terms of having to follow this rule in the future. And I would just note that there's no precedent setting in relation to planning applications. Every application is reviewed based on its own merits. So the approval of this application would not allow others to expand legal non-complying dwellings as of right. There was a note about the garage on the drawing not being a garage. So I would just note that we have received an updated drawing from the applicant with that structure now labeled as a sleep cabin. Further, the updated drawing clearly notes the setback from the sleep cabin to the high water mark. There was a question related to whether the septic system is within the 30-meter setback. So I would note that the septic system is located within the 30-meter setback, and similar to the dwelling, it would be afforded legal non-complying rights. There was a question about the Conservation Authority's involvement, and I can confirm they have been involved with each stage of the application, beginning with pre-consultation and finalizing with this application, and they have noted no concerns with the approval of this application. There was also concern about the notice related to how it was delivered. And I would note that the notice of the application was provided in accordance with provincial requirements as outlined in the Planning Act. And notice was sent to all applicable parties at their noted mailing address. So that wraps up my review of the concerns noted in relation to this application. So I would just finalize by saying, again, the Conservation Authority have noted no concerns in relation to this application based on their regulatory policy. Staff have reviewed the land use documents of the plan of the township and would note no concerns and recommend approval based on the conditions included in the staff report. Thank you.
You received any other public comments?
Yes, we received written comments. And so Kyle summarized the one. So that was from Elise Boisclair and Peter Champagne. That was a letter of objection from them. And then we also received, which have been made available for viewing, 4 comments of support. And those are from Courtney O'Leary, Annette and Terry Carr, Linda Kennedy, and David Duggins and Vicky Woodside Duggins. That's all the written public comments we've received.
Okay, thanks, Amanda. Is there anyone here in the audience or online that wishes to speak to this application? See anybody?
Yes, we do have someone. Just one second.
Hi, good afternoon, Chair, Executive Committee members. My name is Maria Pound. I live at 936 Kendricks Lane on the same road as this application. And I just wish to, I have seen the proposal and I'm just in support here today for the renovation.
Okay, thank you very much.
Yes, we have one more. So I'm just going to call that one forward. Was that it? If anybody else wishes to speak, can you raise your hand again? Because I thought I had one more with a hand raised. Oh, perfect. Thank you. Okay.
David?
David, are you able to unmute your microphone?
I don't think it can. When I'm on here, I don't see any ability to kind of
can hear you
unmute or
now.
anything.
We can hear you.
Yep. If you can, if you have any, if you'd like to say your comments, you can go ahead.
No, Amanda, that was
Eamon.
me.
Sorry.
Yeah,
you,
it's
yes.
yeah. Sorry, it's Eamon. There's no ability to mute or unmute, unfortunately, online. So I don't think David can unmute. But while he's waiting, I'd just like to say just a couple of things. Number one, we didn't want to renovate. We have to. The building has become uninhabitable. There's black mold all over the ceiling. We had multiple contractors come in to try and get a quote on replacing the roof, and it just got to the point where we couldn't do it. It was just the price of doing that of renovating the roof got too expensive. So we didn't want to do this, but we are where we are now. And the problem is that back in 1963 or whatever, when this was built, these bedrooms are only 7 by 8. They're tiny. So if you're just modernizing it, that's all we're doing. We're not increasing the number of bathrooms. We're not increasing the number of bedrooms. We're keeping it. We're just modernizing it. So I hope, the person who sent in that complaint understands this. We're not trying to go above and beyond anything that it doesn't already have, other than just modernizing it with a little bit bigger bedrooms, kitchen, and family room. And then the other thing is where it is. The property has been built according to where the current cottage is, and that includes our fence, our gates, our steps, our access to the water, where we planted trees, all of that kind of stuff. Is really the reason why we want to keep it exactly where it is. We're not going any further to the lake. And I should note, on this side of the bay, we're the furthest back. All the other cottages are closer to the lake than we are. And so that's why we want to maintain the same footprint that we are and expand towards the road.
Thank you. So David, I see you're able to speak now. So if you'd like to provide your comments.
Hi, yes, Dave DeMello calling, and I'm a neighbor at 920 Kendricks. Just calling in for support of this development. Our children play together, and I do have concerns about the serious nature of mold, and I've forbidden our kids to be in that cottage. So a new dwelling, a new building would allow for them to hang out again together. I completely support this proposal.
Thank you very much.
Committee members, any questions?
Yes, I'm now a little more confused than I was before the file was open today. My understanding was that the existing cottage was going to be knocked down and replaced with a new dwelling that was a somewhat different footprint than the existing dwelling. Mr. O'Leary, you were talking about renovating the existing structure. I'm not clear on which you are doing. And when I visited the site to look at the proposal, I didn't see any staking, which would be applicable if you were expanding the footprint of the dwelling, even to, by my reckoning, the east and the south. So perhaps you could clarify.
So maybe I used the wrong terminology. We wanted to renovate, and what I meant by that is we wanted to replace the roof and the floor, and we've now subsequently changed our minds. We're going to demolish the structure and rebuild a brand new one.
Thank you, but the footprint of the new structure is different from the footprint of the existing.
That's right. That's correct. It's not going any further towards the lake, but it will be going 5 feet to the east, and then I believe it is 25 feet to the south.
So can I ask why it was not staked, or if the stakes were put in place, they were gone when I was there a few days ago?
I apologize. I didn't know that the stakes needed to be there.
This is a matter of principle for this committee, so I will defer to my colleagues because it is a matter of principle with this committee.
Yeah, like the building department or Amanda or whoever should have made you aware that they have to be staked about 2 weeks. I think I'm right, Amanda, or 10 days. Yep. Because you should have been made aware.
Apologize. I must have misread what the instructions were. So the instructions I had were to go get the permitting signage and put it up in front of the park and in front of our cottage, and I didn't see the staking.
It's okay. Yes, it was part of my email on July 4th that it needed to be completed by July 13th.
Cool. we're left with a kind of a conundrum here, folks. What are we gonna do? Are we gonna make them hold off another month? And I mean, that has been our issue in the past when they weren't properly staked. We would defer it for a month because, somebody watches and said, well, the guy at Kendricks Park didn't stake it and you didn't hold him back. So, and we have done it in the past. So I'm gonna defer to my colleagues now. How do you guys feel about this?
I normally would lean towards deferring it for a month, but in this case, the slight increase is away from the water. So I could swing either way on this one.
Yeah, same here. I could go either way. I saw it and I understood the application, but I know our process. So I guess depending on how we start voting.
God.
I was on site on July 24th. I can confirm stakes were not there. That said, I was able to delineate where the proposed expansion of the footprint of the new dwelling would be. And so I both respect the policy stand that this committee has taken, but at the same time, on a personal level, I was able to figure it out quite easily where the new building was going to be. So, and it's quite a large chunk of land. So I wasn't overly concerned if it was 25 feet or it says 31 feet here on this drawing, whatever it is. There's lots of room.
Okay. Now, Amanda, we have to vote on this, or what are we doing?
Yes, well, the resolution on the floor is to approve the application. So if we would need a mover and a seconder for that, and we would vote on it. But if no one wants to move on that one, we would need somebody to bring forward a resolution to defer your application.
I'd be willing to try that in English. I'd be willing to bring forward a motion that we approve the application as is, based on the conversation that we just had.
Somebody else? You need a seconder.
Yes, I'll second it because I'm going by the schematic, and it shows that the additional floor space is going no further to the water, and so in this particular case, I'm okay with it.
Okay, it looks like we would pass, but I would like the applicant to, how would I word this? Not think that it wasn't supposed to be staked. I mean, I wish people would be encouraged to read a little better because Amanda already checked and it was there. In this case, it's not in the winter. It's not covered with snow, which has been the case many times, and we have deferred them. You have to mark them. But actually, in this case, I was out there over a week ago, I guess, and I could see where it went. But if you're talking to any of your friends that are building, encourage them to have it. Maybe the next time we wouldn't be so generous. We've already had a mover and a seconder to approve it as that. We don't all have to agree. But so did you get an over?
Yeah, it's been moved by Todd, seconded.
Okay, it's been moved by Todd, seconded by Bruce, that application, but I get my cheaters on here. D13-2025-026 be approved subject to conditions as included in the planner's report and the decision of the committee, and lead a vote.
I'm going to vote against this motion. It's essential that I give reasons why I'm voting against it. And so I will. I think we have set a very consistent and appropriate policy about staking. It's not only about the seasons, it's also about getting perspective on the structures that are being proposed. And with a visual, you have a better perspective, regardless of whether or not you're able to read the diagrams. And I am certainly able to read the diagrams. So I realize that it's an inconvenience for the applicant, but I do think that the applicant was informed of what our policy is. And whether or not it was willful, I'm not going to suggest it was, but it merits, in my view, deferral.
Okay. Bruce?
I vote in favor of the application or the proposal.
Paul?
In favor.
Tom?
Yeah, I vote in favor and would add in the, what I meant to mention when I made the motion, the health concerns that were noted as well, I think come into play in my mind.
Okay, reluctantly, I am going to support it because I was one of the main pushers for having the mark, but in this case, I didn't have any issues with seeing it, but I agree it does not set a very good precedent. So it is carried.
Thank you, everyone. Okay, so now we are on to our last order of business. Which is the discussion on small accessory structures within the 30-meter high watermark. So our Director of Planning and Development, Marnie Vendetti, has come into the meeting, and I think she'll lead the conversation.
Thank you. Through you. Amanda, did you hand out? I left a stack of these. No. Thank you. So in response to the discussion that was had at the committee, we have pulled some information together. It's certainly not in the form of a recommendation or a full report at this point. So this is information for the committee to review. In looking at it, well, we recognize that it may seem quite administrative to allow a certain percentage of development within the 30-meter setback. Given the variability of our shorelines, and we're not just talking about the 30-meter setback, we're also talking about the floodplain as well as natural hazards and slopes. And we went through a number of iterations. I can tell you that the planning team has spent a lot of time sitting down thinking this through in terms of the different iterations and what it could be. And so what we're talking about is gazebos, unopened unenclosed decks, sleeping cabins, hot tubs, all of the different structures that people like to have between their cottage and the waterfront. And in doing the research, we did find a couple of municipalities that do have some exemptions for smaller size structures. And so the Conservation Authority does not permit certain structures under a certain size within the 30-meter zone. I believe their area is 15 square meters. The building code does not require a building permit for a structure under 10 square meters. But in looking at it from a zoning perspective, all structures are required to comply with the zoning bylaw, which establishes the setbacks. We went through a number of iterations, and we also looked at the number of applications since 2022 for permitting structures within or doing variances to allow structures within the 30-meter setback. So in looking at that, what we found is that it represents a total of about 3.5% of the applications that come to this committee in terms of the number that are requesting structures within the setback area. When we're looking at a minor variance, we have to look at our official plan policies. We have to look at a provincial policy statement that all look at natural hazards and those types of things. So one of the things we had a hard time wrapping our head around was if we were to allow an exception based on a certain floor area, there's nothing to look at the area where somebody wants to put a structure. So it could be in a hazard area. It could be on a slope. It could be something that gets cantilevered up on an edge, which are all things that we see people building without permits quite frequently. And so in looking at that, we do have some concerns with allowing any structures as of right within that setback area. Our official plan contains policies that says in certain circumstances, it may be appropriate to allow small sized unenclosed structures within the 30-meter setback, which then allows us the ability to look at those through a minor variance process and look at a proposed structure and say, okay, it's not in a hazard area. It's not on a slope. There's no impact, and it allows us to look at that proposed structure in the context of the 4 tests for a minor variance. Our concern is if we were to provide an exemption, we don't get to look at that, and we may end up with structures in hazard areas. And so based on that, we do have concerns with bringing that type of a change forward. So what we did was provide the information for the committee to look at. We're not bringing forward a formal recommendation. And so we wanted to have some discussion with the committee around that to see what your thoughts are. It's not the end of the discussion, it's the beginning of the discussion at this point, I would say.
Thank you. My initial reaction is to strongly endorse your analysis. I think that there are 2 factors. One is this committee has always, I think, heavily and rightly relied a lot on visual inspections of things, which teach us a lot about what people are actually proposing. And the second thing that I am concerned about is the nature of the blank check. Because, particularly on waterfronts, like anything goes unless it doesn't go. But by the same token, this committee, anyway, I think has been very practical in terms of its decision-making about what goes and what doesn't go. So my initial response is to support your analysis.
Yeah, I agree with Catherine. I'm just wondering if there couldn't be a simpler, less costly way to handle request for a small structure. So it wouldn't have to, incur the expenses. I'm just wondering if it could still be looked at and still have to have some kind of permit. But I'm just wondering if there's any thought of trying to do it more economically.
Yeah, I was looking like a 15-meter setback myself for like a garden shed. I would think that anybody building one wouldn't build it on, you would think they wouldn't build it on a slope or in a hazard. And when you're 15 meters back, there's typically no hazards like the floodplain. Even if it is a garden shed, I don't even know if that's an issue. Like, to me, it's not, but I know to the conservation, it might be to them, but they don't issue permits for these anyway. So I don't have any, I've seen enough of this stuff that 15 meters is a huge distance, 50 feet. Like that's, you can put a house in there literally. Anyways, that's my thoughts.
Todd.
Thanks for the information. I'd like to take some time to review it, obviously, and analyze it a little bit. I agree with my colleague around the blank check comment. I don't think that was the goal or of the request was to issue a blank check. I think we still have to have oversight with respect to those types of things. Questions I have are around duplicity. So what duplication is there between going through this process, both not both, but on a oversight perspective that is also done at the building stage and the building permit stage? And is there duplicity there? Or is there an opportunity to, for certain types of building applications, to combine the processes? To Bruce's comment around cost, I think cost, it was one of the big pieces for me. The cost to go through this committee, it was in something we read for one of the applications this time, but $825 and $445. And I think the application that I read, it was like $2,800. If somebody's putting an above ground swimming pool or a garden shed or something like that, to me, that's it can be a large percentage, or in some cases, perhaps even more if you're building it yourself, than what the actual structure is going to be. So that's where I think the sticking point is for me. Not looking at all to, put out any sort of a, I'm going to steal Catherine's phrase again, a blank check type scenario, but looking to streamline both from a logistical and from a financial perspective to make it easier for individuals to upgrade and enhance their properties, which is what they're doing in this instance. So, but I would like time to review that more. Thank you.
Okay, thanks, Todd. The only thing I'd say is I think I got what you were saying, Paul, right? You were thinking that as long as you were 15 meters back, that would be reasonable for a garden shed or gazebo. And I tend to think that too. Like most people aren't going to build it where they think it's going to float away. I mean, they own the property. They had regardless of the 100-year high water mark, if they've owned it for a number of years or whatever, they'd have a pretty good idea, or even looking at topography of where the high water mark is, that they'd have to worry about it. Like, I think 15 meters would be more reasonable. I'd like to state that that would be my recommendation. So that's it. That's all for me.
Just to provide a little bit more information around the costs. And your question about the duplication of process. Building cannot issue a building permit for something that isn't compliant with the zoning bylaw. So from a building code perspective, there's no ability to look at the zoning bylaw and provide any variance or have any flexibility in terms of looking at zoning. Now, the provincial government recently has put forward proposed amendments to the Planning Act to allow some minor variances as of right, but that's only as it relates to housing and yards. So if someone was coming in for a single family dwelling and they didn't meet the side yard requirement, what's proposed is that there's sort of an automatic buffer of say 10% of what that setback is, which would be an as of right permission under the Planning Act. But that wouldn't apply to the types of structures that we're talking about right now. So there's no duplication in terms of the review. The Committee of Adjustment is the only committee that has the authority to provide any relief from the zoning bylaw. The only other opportunity would be through council through a zoning bylaw amendment. With respect to costing, the cost depends on the nature of the application in some cases. So for example, if it's an open, unenclosed deck within the 30-meter setback, it may or may not need a review from a septic perspective if we know where the tile bed and everything else is on the property, because it's not going to impact the septic capacity of the structure that's on the property. The actual fee that we charge for a Committee of Adjustment application, don't know the exact amount off of, is it 800, 850? That's a pretty bare bones fee when you consider the receipt, the circulation, the mail out notice, everything that staff puts into the processing of an application. I'm certainly not downplaying that fee for somebody that's putting in a gazebo or something. That's a significant cost, but from a processing perspective, I don't think that I could recommend reducing that fee any lower than what we're already doing. In fact, I think some of our fees are quite on the low end when you look at some of the surrounding municipalities. That being said, there's still additional costs such as a conservation authority review fee if it's within their regulated area. So all of those costs do add up, which would be something different if we had it allowed as of right, especially when the conservation authority is reviewing an application for minor variance in an area where they don't regulate or have no, they're not going to issue a permit for it. So their comments are going to be, we don't care. I'm just simplifying their comments there. I'm putting, that's not the way it would come across, but so I think it's something we can look at. I don't think it's as simple as saying 15 meters from the high water mark, because 15 meters from the high water mark, depending on the property you're looking at, could be on a slope, could be on a ridge, could be in an erosion hazard area or something, which is where we had a hard time wrapping our heads around some of it in terms of how do you do this as of right. I understand the average person isn't going to set out to put a garden shed or an unenclosed deck in a dangerous area, but we've seen a number of people building things without permits in dangerous areas that then turn into very expensive enforcement exercises for us in terms of a municipality. So it's not a one size fits all solution. So what I would say is we can take back some of the comments that you've brought forward today and look at them. And if there's anything else that comes to mind when you go away and look at the information, let's have some more conversation about it.
Thanks. I really, I'm having a really hard time with English today. I appreciate the clarification. And so based on those comments and the legislative obligations you described, would there be an opportunity as opposed to saying, distance, to type of structure or something like that? I don't know the answer to that, but I bring that forward as an opportunity. Thank you.
Yeah, well, just to Todd's point, which I think is sensible, the type of structure, but even in the time that I've been on this committee, I've seen applications for certain types of structures, which have turned out to be other kinds of structures when they have been finished. And I go by one in my boat every day. And so that's, I think, an issue. And it's an issue of enforcement in some respects, but it's also reminding people that there is a regulatory process that needs to be respected.
Bruce, you want to add something?
I kind of reluctantly agree with our director of planning. I understand where she's coming from, but as I said before, I just wish for some of the smaller requests that there was something that we could do that would not be as onerous on the resident. And I know what Catherine's talking about, and I think I can probably pinpoint, and I don't know, I don't beyond Graham Lake or Charleston, but anyhow, no, I'm good with the status quo, but I hope for changes.
Does the township post a breakdown of its costs for processing applications anywhere? I mean, if I haven't had the occasion, so if I went on the township website and sort of said, okay, what's it going to cost me to apply for a building permit to put up a garden shed? Is there any like sort of transparency upfront to the public about what it would cost?
All of our general rates and fees are available on the website.
Good, great.
I guess just a question for yourself, Marnie. If you're 30 meters back, you don't need the Cataraqui. And so if you're on a sloping lot that slopes beyond the 30 meters, technically you could build your house on the side of that, your garden shed and so on. I don't really see the difference between 15 meters and, because I've seen like 90% of the homes in this township on the water, probably 95% are in that 15 meters. And I haven't seen one fall in the river so far. I've seen trees fall on them. That's probably a bigger hazard than all these other hazards. But anyways, I've seen houses cantilevered over the water that have been there since the 50s and all sorts of things. So I look at it slightly different, I guess, than than what the conservation or whatever looks at it. I think people are probably smart enough that they're going to put it that they can easily get to. And if you're not living in it, I don't think people would put it in a hazard anyways. Maybe somebody would, but I wouldn't. I don't think anybody here would, but common sense prevails typically, but it's not a living, like it's just to put some, if you have water toys or whatever, you stick them, you don't want to walk 100 feet up the side of an embankment to drag your kayak or whatever. And that's my perspective on it. Thank you.
On a side note, on the waterfront again, regarding living accommodation over top of boathouses, I know we don't allow that. But they do exist, have existed for 100 years with no problem. And I know in today's engineering world, where docks can be pile driven down to bedrock, I'm wondering if we're not, we're not allowing building or habitation over top of boathouses, but if they can be safely built, and we're all aware that they can be, there's never been a death yet in any of the boathouses that are two-story on the river that have been there for 100 years. And with today's, engineering and pile driving and et cetera, I personally, I have nothing against living accommodation over top of boathouses, if they'd be done safely. And as long as the health unit, well, it's not health unit anymore, as long as the sanitary requirements are met, what is the hazard?
Go ahead.
That's a much bigger can of worms to open. Yeah, that would be contrary to the provincial policy statement as well as our official plan and the Conservation Authority regulations. So that is a road that has been closed in terms of building over boathouses and building over water. We also don't have the same regulatory authority over the water necessarily. So we can't really go down that road.
The only thing I would add on the minor variance, I've been at this a while, a minor variance triggers other costs. So I think you alluded to that, whether it's the Conservation Authority and other permits for here and there. And I've done quite a bit of building, and I can tell you now, I could build a storage shed, buy the lumber and build it myself for less than the cost of a minor variance. And this is where I agree with Paul on the 15 meter. If it's 15 meters back from the water, that's pretty well 50 feet, eh? You're taking this back for our input. I don't see any issue with that. Like me personally, like you'd have to be simpler than most people are. And there's always the exclusion to put it in a place that it was unsafe. So, I think there's a lot of times I've seen minor variances here over the last, 15 years for something like that. That's just actually an added cost. That's just my opinion. I'd like you to take that back. I have nothing more to add. I don't know about anybody else.
Just a point of clarification. When I was quoting costs earlier, I found the email trail was in the documentation for today's meeting. It included $1,300 in site plan control agreement fees, which I will fully acknowledge are not applicable to every single situation. So I didn't want it to seem like I was blowing the costs out of proportion. The costs themselves were noted in the around the $1,500 range, and the additional was site plan control, which I know it doesn't apply to every situation. So just wanted to clarify that. Thank you.
Okay. One more thing for our secretary.
Lindsay
okay.
would like to
Yes, go ahead.
Through you, Chair, just to speak to the 15 meters versus 30 meters. It is also an exercise in protecting water quality when we look at development adjacent to the water, and the 30-meter minimum setback is kind of the universal standard across many municipalities in the province as the minimum setback to provide for the proper water quality protection and the opportunity to create that vegetative buffer that we all want to see, especially along Charleston Lake. So with water quality coming out of the scope of what the Conservation Authority looks at, it now falls to the Township Planning Department to look at that as well, which kind of lends to the value in looking at each of these requests individually so that we don't overlook the water quality and natural heritage protection interests in an application.
Bruce?
I'm only going to wander off subject one more time. A lot of our applications lately see the term permission. And I'm just wondering who in the planning department would like to sort of give me a short rundown on what the permission is aspect of the application.
So a permission is, a minor variance, I'll start with a minor variance. A minor variance is when you have construction that is new construction. So a shed would be a new use on a property. The setback is required to be 30 meters. And so that wouldn't be a permit, that is a variance. So you're going from say 30 meters to 15 meters. that's a minor variance. A permission applies when you have existing development on a property that doesn't comply with the zoning bylaw. So under section 45(2) of the Planning Act, it's permissions. So if you have existing non-complying development, which means something that was built prior to the zoning bylaw, but was compliant at the time that it was built. So if it was something that was blatantly non-compliant and has never been compliant, it's never going to be compliant. But if you have a legal non-conforming use that was built in accordance with the bylaw of the day, and somebody wants to expand that or change that, that's a permission. And so the tests are a little bit different when you look at a permission versus a minor variance where you have the 4 tests. A permission is, does it make the situation worse? So is really the main test of that one. So if you're looking at a new deck or a new shed or anything that's entirely new, it's not a permission, it's a variance.
Thank you.
Before we shut down,
Hold on. Paul was thinking. Okay.
I have a question for Secretary.
Mhm.
View of what just happened here,
Mhm.
which Catherine certainly wasn't happy with, and I wasn't real happy with.
Yes.
Have a highlighter when these go out. You know what I mean?
Yes.
That-
I actually started bolding it in the email, but I understand I need to.
You can't
No,
make
no,
people
no.
read it, but then they would have no reason. Oh, I didn't see it. Well, you need your glasses adjusted or something. You have it highlighted in yellow or red or some damn.
Yes, and I always try, like when I'm at the counter with people, to explain it to them as I'm taking their application. It is bolded. It's a whole other section at the top of the email that says important information. And as you go down, it literally says, please read this entire email. That's the first statement I have at the top of the email.
Easy looking at the comments to read it.
But I like your idea of highlighting it. So
For color? No,
Yeah.
my wife does that. I don't use it.
I can highlight, yes.
Well, and then the next time this happens, I'm gonna have to wait for Catherine. I said, are you colorblind? You know, there has to be a reason for this. Okay, Catherine.
Okay, so I agree. All good. I would suggest adding to that, again, highlighted, failure to do so will result in your application being deferred.
Absolutely. No, I would have no problem recommending for a deferral in the future. Now, we should put this to sleep. Like, it
Well-
was awful. Bruce, for years. We went in the middle of the winter, and there's a field. Where the hell's the house gonna be? You know, and now we've got that pretty well taken care of, and it's been a couple times they've missed it.
My comment is, I think that some people might read it and see that it needs to be staked, but they misunderstand and they think that when they stake the sign into the ground, that's the staking that's required.
We can clarify that.
So I will clarify. So in the email that I send everybody, which would probably print about 2 or 3 pages long, in bold, in caps, this is important information. And then it talks about the sign posting and explains how exactly to do that. And then below that, it says staking of the proposal to be completed by, in this case, July 13th. And it says the Committee of Adjustment passed a resolution requiring that the proposed development, subject to the minor variance, is required to be staked or otherwise marked a minimum of 15 days prior to the hearing date. This is required to be completed by July 13th, 2025. The committee may defer your application if the proposed development is not staked on time. Once staked, please take photos and email to my attention. I can then provide these to the committee members and staff for reference when they are on site. And so this month I was on vacation the week that they were coming in, so I didn't check that part. I always make sure that we get the sign posting. So it's not like I'm spelling it out, I think, the best I can. But I think I agree with the idea of maybe highlighting and
You can change it.
trying to get it clear.
Change the word.
I can't because I don't have the right to tell somebody that you will 100% defer when, in this case, you didn't. And so I can't, all I can tell people, and when I'm talking to them at the counter, I've literally said to them, the committee has deferred one of our applications because we didn't have it staked. So I'm trying to make it clear to them at the counter that this is a real possibility without saying
Without
you may
saying
not get it
changing
done.
May to will.
Yes.
That's what I was gonna say.
Yeah.
Will. Well, in the
Yeah.
future, I think. Like you have, no,
I'm wondering, Amanda, if it should say that staking the development, like, or the new development.
Yes, that's right.
Yep. So if we can just finish the last topic we were on, I think the agreement is we're going to table the discussion on the small accessory structures. And then I can bring it back forward to the August meeting. This will give you all time to read through the documentation, make your notes, collect your thoughts, and then we can discuss it further at that meeting if you're all good with that.
And for clarification, should the committee after the August meeting wish to put forward a recommendation, that recommendation goes from the committee through to council at large, or that goes back through you folks and up to council?
A little bit of both.
Yeah.
So if the committee makes a recommendation to council and passes a resolution, it would go forward to council with a staff report.
And now we can adjourn if you're all ready.
Bruce, Catherine, all in favor?
Thank you, everyone, but you have to speak into the microphones because we're still recording.
I agree.
Yes.
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 That the committee will adjourn to meet again at called secretary treasurer. Unanimous.
Perfect. Thank you very much, everyone.